Good afternoon, everyone. Thanks very much for tuning in. This is obviously Zach Lucas, Spencer West. This is part of the Wealth Talks series of webinars. Today, I'm joined by only one person, and we're very lucky to have him. It's David Brownbill QC from 24 Old Buildings in London. Now, I've known David for many, many years. We've happily had some work together as well. And David has taken time out of his extremely busy schedule to help us out on this topic today, which is the Family Office Trust. And so I'm immensely grateful to David for doing this, because it's extremely rare for us on this side of the world to have someone of your level helping out and discussing some of the topics of the day. And this one particularly, the powers and trusts, is something that is not dealt with very often, that I can see in the Asia market. And so it's timely that we should have this conversation, this particular run through on the Wealth Talks seminars and webinars. David may, if his schedule allows, do further webinars with us during this year, which will be very much gratefully received. But for today's purposes, we're going to be running through, as advertised, the sort of Family Office Trust. Now, before we get going with the agenda, as with always with the Wealth Talks, there's an admonition that this is a discussion between two practitioners and is not in any way to be relied on as legal advice. So you shouldn't take any action on it or inaction on the basis of what we say today. It's honest advice and honest guidance, but it shouldn't be relied on as constituting any sort of legal relationship. So I need to say that at the beginning. It's also contained in the slides, etc. Now, this, as usual, is being recorded. So after the event, if you registered your viewing, then you'll get a copy of the slides. You'll also get a link to the recording. And then there is, of course, the podcast audio for those of you who don't want to view anything. Right, so for today's purposes, the agenda that we'll run through, we'll do setting the scene on the Family Office Trust and the governance framework that seems to be developing in family offices across both Singapore as well as to an extent in Hong Kong. We'll look at the concept of excessive reservation of powers and what seems to be happening on a thread of decisions that's sort of creeping up on us, and how the courts have been dealing with reservation of powers, particularly to settlors, and the effect it's having on the validity of the trusts. So it's one that's current law, and certainly the decisions are very current. The one that we'll discuss in particular, the 2020 decision in Webb. Now, decide to look very carefully at Hong Kong and Singapore, because here we have sort of limited statutory codes when it comes to the applicable trust laws, and limited statutory codes to the extent of reserved powers. And so wanted to juxtapose the developing case law internationally to the position that we've got in the two major financial hubs in Asia. Then we'll run through and canter through the countermeasures that we might consider as a way of taking into consideration the developing case law, the risks that they pose, and then what you can do to try and remedy some of these risks. Next actions is just the action points, what I think is the honest advice to any of you tuning in, whether you're from trust companies or you're in a bank and you're responsible for development of this type of work. What can you be doing going forward on the back of this, talk? So I'll do a general introduction on the governance framework, and then we'll start to get into the case, and then finally we'll hear from David and we'll enter into the discussion. So as always with these talks, it's going to be diagrammatic. And I want to start with the simple structure of a trustee, and the underlying asset, the trust fund. And what we'll concentrate on are effectively the two parties to the trust that traditionally hold powers, the settlor and protectors. And when I say protectors, I mean non-settlor protectors. So these are third parties that are not otherwise connected. The settlor will be the mainstay of the discussion because the case laws are really focusing on that. But I want to also discuss whether or not there are any issues that give rise on the protector side where there are non-settlor protectors involved. And I'll be inviting David to make some comments about that as we go along. Now, here's the important aspect. We're going to divide up normal trust powers into a bunch of different segments. And so the one that I'm going to start off with is the administrative powers. And I've put a list down. This is not exhaustive, but it gives you an indication of the type of powers that would be typically within the administrative list. So investment powers, appointments to appoint and remove directors of underlying companies, investment managers, change proper law, change the exclusive jurisdiction clauses. So these would be traditional administrative clauses. Then we have quasi-dispositive clauses, and this is powers to amend, vary the trust, power to add and remove beneficiaries, power to appoint and remove the trustees. So they don't touch on actual transfer of assets, but they indirectly do because they change the parties involved potentially. And then we get on to powers of dispositive powers proper. And there we have powers of appointment, powers to direct income, and then importantly, power to revoke the trust. And finally, we deal on with restrictive powers or restrictive provisions, which basically seek to reduce the amount of accountability that the trustee has, or otherwise reduce the ability of beneficiaries to seek redress. And so I've put trust information, legal redress, and obligations. These are restrictive of what would otherwise be considered the ordinary sort of obligations and rights of beneficiaries, trustees. That's the matrix. Those are the powers. I think it's important to keep in mind that we split it in this way, because later on in the analysis, you'll see bits of this where the powers that are reserved become ones that become worrisome, and others are not so worrisome. So it's important that you keep in mind this split dichotomy. Unfortunately, given that this is trusts, it's going to be complex. So there's one other filter that we need to keep in mind as we go through. So when it comes to settlors, particularly, we will also look at it in the context of what type of power or the scope of the power. So there's the difference, blandly. Power to direct means that effectively the settlor has the power to tell the trustee what to do in certain circumstances. Power to consent is where effectively the settlor can authorize something that the trustee wishes to do. And then at the bottom, we have the different forms of powers or the quality of the power. And then we introduce the concept of a fiduciary power and a non-fiduciary power. And we'll get to what this means when we run through the case analysis, but it's important. So we've got the dichotomy of administrative, quasi-dispositive, dispositive, restrictive, and then we've got to filter it for powers to direct and consent, and then whether or not the power is held in a fiduciary capacity or a non-fiduciary capacity. It's quite a bit, okay, so I understand that, but it's important that we keep it in mind, because the way that this configures up makes a big difference in the court's attitude to the position of the settlor in the trust, and ultimately to how the trust is effectively validated. I don't know, David, just running through that, is there any other filter that we could think about that would be relevant when we actually begin the analysis work?
I don't think, for present purposes, that we would have any further ones. I mean, as we will discover in due course, the settlor's personal powers to give directions to trustees could itself be divided between beneficial or dispositive powers and administrative powers.
Yeah.
See that the administrative control is probably on one side of the balance sheet, and powers for dispositive are on the other. Yeah,
right. Okay, so the developing case law. Now, this is the important aspect. There are many cases in this area. They sort of reinforce each other in a way, but the ones that, just for present purposes and because of time limits, the ones that we'll concentrate on are TMSF, and that's a case originating in Cayman Islands that went to UK Privy Council. Then we have Pugachev, which is a UK case. And then we will end with Webb and Webb, which is a Cook Islands case, which actually ended up in the Privy Council as well. And you'll see the timeframes, 2011, 17, and then 2020. There are other cases that we can mention. There's one that actually comes on the other end of 2020, which is the Dewar case, which we might have time to discuss. But these are the main ones that we will consider. And what we're trying to achieve is show a thread of how the courts are seem to be meandering into an area what they term the illusory trust, although they don't actually like that term, although it's probably going to stick now. But the illusory trust, which is the effectively invalid trust. But we'll get to how that works. So starting off with TMSF, and I'll just do the general background, and then David and I can discuss what was actually going on in this case. All started with a failed Turkish bank. The settlor was found to have misappropriated assets. Settlor had judgment against him, so he's judgment credited to the Turkish Asset Collection Agency. Settlor had created a number of trusts in the Cayman Islands. Now, when you look at those trusts, just bring up the screen. Actually, the powers in contention on that was the power reserved to the settlor to amend and vary the trust, and then there was a power of revocation. Okay, and this is fairly important in the way in which they then went on to analyze the power of revocation. So these were the principal powers. It wasn't a very complex reserved power position, just power to amend and power to revoke. Now, in the court decision, David, I think probably it'd be useful to set the tone of this, because there was a broad discussion in the court around the distinction between powers and property. And so it would be helpful to run through why that matters, why it makes a difference that we go from analyzing the position of a settlor holding powers to a position where the settlor is effectively holding property. Why did they make that distinction in this case, particularly with the power to revoke?
Yeah, there was a very unusual circumstance in this case. And as you pointed out, this was a chap who had become bankrupt in Turkey. And the Turkish bankruptcy rules didn't contain provisions which pretty much everybody listening to this podcast would be familiar with. And that is that when, in most of the common law world, a person becomes insolvent, becomes bankrupt, not just his assets vest in the trustee in bankruptcy, but so do his beneficial powers. Obviously not fiduciary powers. So that if in the ordinary course of events, this case would never have happened in say, Singapore, because the power of revocation would have been automatically vested in the trustee in bankruptcy, who could have exercised it. That didn't happen, couldn't happen in this Turkish insolvency, so some other way had to be found. And the other way was to try to have a receiver appointed over that power. Historically, receivers can be appointed over property.
Right.
They have that's the issue. Was the power property? And that we don't have to get into it, becomes highly philosophical. But there's an old case, probably a good century old, when a judge had indicated that powers are not property.
Right.
And they had to get past that. For what it's worth, I think they way overcomplicated the matter. These powers are clearly rights. The rights are generally assignable, and they can be assigned for a value. They can be, if you do tax at all and you do capital gains tax, capital gains is charged on disposal of property or assets, and that's described as anything that can be turned to account. You think about it. So it shouldn't have been so complicated. It was, but that's the reason why it became important.
Right.
And of course, as you know, the court analysed it by simply saying it was tantamount to ownership.
Right. So they actually said that by having a power of revocation, that was tantamount to ownership of the trust fund, in effect.
It was tantamount to ownership, but the good part of TMSF is that it didn't cross the line that appears to have been crossed in the other cases.
Right.
It simply said that here's this power, we treat it as property, therefore it can vest in the, you can appoint a receiver over it. And all happened is that the power had to be assigned to the receiver.
Right. So
nobody said the trust was invalid.
Right. And see, that's the main point, isn't it? That they had they had accepted that the power of revocation was equivalent to property ownership, effectively, but it didn't invalidate the trust.
Correct.
Right.
Yeah.
So they allowed, and they
in
also,
a way, it's untroubling to us.
right. So that was, so in that sense, it was quite orthodox then,
Yes.
that you could have a power of revocation and not have an invalid trust because of that.
Correct.
Right. And then they also said that the power of revocation clearly was non-fiduciary because you could exercise that power for your own benefit, clearly, as a settlor.
Yeah, absolutely. And it would be very difficult, wouldn't it, for a power of revocation to be fiduciary?
Yeah, exactly. Right, right. So that seems to be a relatively good start to this analysis, right? Because we've got a situation where there's a power to revoke. Everyone that's doing US work with, foreign grantor trusts, they will have powers to revoke, typically in those trust documents. So far, TMSF is saying that, yes, it's tantamount to property, but it doesn't invalidate the trust. The fact that you have this power, in other words, to get back the property, doesn't invalidate the trust. That was the position in TMSF.
Absolutely, and the key theme in all of these, at least in the legal analysis, the traditional one, was that the power exists. It is on your balance sheet, that power, but until exercised, the trust is still extant and still valid.
Right. So then things start to change after this decision. Because this is quite orthodox. Power to revoke can coexist with a valid trust. Then we have the Pugachev decision, and this one begins the train of decisions that actually starts to go against what TMSF was establishing, or at least re-establishing. So the facts in this one: failed Russian bank. There's a lot of banks being failed on these fact patterns, by the way. So failed Russian bank, misappropriated assets, normal fact pattern, judgment against, normal fact pattern. Settlor created irrevocable trusts. So that's different. So they were irrevocable. Settlor was the first protector and the beneficiary of the trust. So he's the first protector and the beneficiary of the trust. This was the mix of powers as it unfolded in this case. There was obviously powers of investment. Protector could direct that as well as consent. That wasn't so determinative. But then there was a lot of quasi-dispositive powers and dispositive powers. So power to amend and vary, protector consent, power to add beneficiaries, protector direction. Remember, the settlor is the first protector in this case. So power to add beneficiaries, protector can direct that. Power to remove beneficiaries, protector can consent to that. Power to appoint trustees, protector direction. So the protector can decide. Power to remove trustees. This was very important in the case. With or without cause, sorry, not case. Protector direction. And then power to distribute, appoint income or capital, protector consent. So that was the mix and matrix of powers within the trust documents. I think the key bit was settlor is a beneficiary, settlor is the first protector, and then there's an array of powers that are allowed, some of which are obviously directive and consensual. So the first bit here, David, is when the court came around to this, analyzing the first protector's powers, they spent a great deal of time analyzing whether or not the powers, because it was held by a settlor beneficiary, whether or not they were fiduciary or non-fiduciary. And I think it'd be helpful to understand why they were doing that. Why were they spending time working out what were the obligations of the power holder? Presumably from the trust documents, they didn't say anything about the quality of the power. But why was the court doing that? Why was it looking at whether or not the protector, the first protector, the settlor beneficiary, why were they analyzing whether or not the powers were held fiduciary or in a personal capacity?
The simple point is that if they are non-fiduciary, they can be exercised for your own benefit without regard to anybody else.
Right.
That's and that in essence is what the court was deciding, and it was perhaps the single most important finding, somewhat contentious, but nonetheless the finding that in all the circumstances, as everybody says, the court found that the powers of Mr. Pugachev were non-fiduciary. He could exercise them in his own interest.
And that was because he was a beneficiary. Is that really what it came down to? He was not excluded.
I don't know that it was quite that mechanical. The court's decision wasn't particularly linked to any particular factor. It's certainly part of the mix. Very often, the natural implication of a settlor reserved power of a dispositive nature would be that it is personal, because it's something he's kept to himself.
Yeah.
But if it's, as we all know, it's a fairly orthodox analysis, if it's held by you as a protector and that's a continuing office, then that usually is an indication to the contrary, and that it's not a fiduciary power. My apologies, that it is fiduciary.
Yeah, because they in the judgment they discussed that had this power been had the protector not been a beneficiary or not been the settlor, things would have been different. They would have respected that the office of protector was in that case fiduciary.
Correct. I mean, in other words, there would have been some tension within the holding of the power. There was somebody had to consider other people,
right,
other than just yourself.
Right. So, I mean, when you in the old books that talk about, the books that are out anyway on protectors, they say that, and they argue this in the case, that the office of protector is generally going to be fiduciary. I don't know how that's perhaps not a good description of it. It's the powers that they hold are either fiduciary or non-fiduciary. But we've always sort of thought of, when you do ordinary trust work, that the settlor will be the first protector. It's quite popular in Asia to have the first protector being the settlor. But what this case is showing is that if you do that and you say nothing else, that the court can draw the inference that insofar as the settlor is the protector and he is a beneficiary, that he's holding the quality of those powers in a different context than if it was a professional doing it, a non-connected professional. And I think was that surprising, David, when this decision came out? I know that it's been criticized in the sort of the sort of press and the technical circles, but was it surprising how they came to this decision, given the fact that it is a protector? We always thought that was an office holder, a fiduciary office holder, and that the fact that he's a beneficiary shouldn't make that much of a difference because he's still under the court supervision when in the office of protector. Did it surprise?
Well, the whole case is somewhat surprising at one level, because this is, for all intents and purposes, in terms of the drafting, you can quibble about the drafting and some overcomplications, but it was basically a life interest trust for the use and enjoyment of a family home.
Yeah,
it is as orthodox and almost standard for a couple of centuries, and there are various provisions in there which made sure that the family home couldn't be sold.
Yeah,
without the life tenants. As would have been in other circumstances, permission, or consent. But yes, it's surprising on another level because, of course, even the power to hire and fire trustees, was held to be not non-fiduciary. Now, I think the words "with or without cause" are just utterly pointless. I mean, they don't. I mean, the notion that you could just hire and fire a trustee without proper reason is pretty naive. Yeah. Whether a challenger can prove the fact that there was no good reason or an improper reason is a different question.
Yeah. What was
they are fiduciary. They're generally speaking fiduciary.
Yeah.
That is one case. Which an old Bahamian case back from the 1980s, in which the court did find that a beneficiary with the power to hire and fire trustees held the power for the purpose of protecting that interest.
Yeah, Yeah.
It was not fiduciary.
Yeah.
Pretty much the only one.
Do you think that had the settlor not been a beneficiary, that would have made a difference in the analysis? I think they said that, didn't they? If he wasn't a beneficiary, that would have been different.
It would have been, because of course that there would have been little to gain for him.
Yeah.
If he wasn't a beneficiary, how otherwise would he have benefited?
Yeah, but you know, the other odd thing about this case is that they do a lot of what ifs. So they go through the scenario there. Oh well, he could have got rid of the trustee, and then he could have got someone in that would have basically did his bidding, and the fact that he would be the person consenting to distributions, well, he just set it up that the trustee be whoever he wants, and they would make the distribution. He would agree to it. So the court doesn't wait for things to happen. It starts to extrapolate hypotheticals where you could abuse the position. I mean, did you find that extraordinary when you read that?
I think pretty much everybody did, because and the theme in the cases that you're referring to, when we come to Webb and Webb,
yeah.
Whereas previously the retention of a power on its own didn't destabilize the structure.
Yeah.
And we can get into why that is in a moment. The implication of these cases is that the mere existence of the power,
right,
not its exercise, is problematic.
Right.
Once again, we've got to bring together all the facts, and I appreciate that some of these don't necessarily go to the construction of the instrument, but it's just naive to think that these are not relevant as to the purposes of the trust. They are pretty horrible facts in Pugachev.
Yeah, because we're always encountering sort of dodgy settlors. So the court is not minded to help them out. And so you think that that's a factor in all of this, is the fact that we're dealing with dodgy settlors.
Yeah, pretty grim facts. And obviously this chap was, I think he'd actually been made liable, not just claimed for a couple of $1 billion. He didn't defend his own trust.
Yeah.
Didn't appear, didn't give evidence. Evidence what was given by family, or let's call them family members, who of course would have been constrained in what they could provide.
Yeah, yeah.
And for good or ill, the director of the trust company in question, it wasn't his evidence wasn't well received, unfortunately. So you're in some difficulty. But nonetheless, on the pure construction of the instrument, it is full of surprises.
Yeah, and then we just finally on this, we get this rather odd situation where they say, well, with the cumulative effect of the powers is that effectively this settlor can gain access to the fund if he were able to, if he wishes to exercise the powers in a particular way, he can regain the fund. And so therefore, the answer is he didn't actually, it was a tantamount to having a power of revocation.
You're absolutely right. The disappointing part is that the quotation from TMSF is relied upon.
Yeah, yeah.
But misplaced.
Yes, yeah.
Whereas in deciding whether the power of revocation itself constituted proprietary a property and could be the subject of a receivership.
Yeah.
Taken that and added to it and said, therefore, you own these assets.
Right, right.
Not what TMSF said.
Yeah, yeah. Okay, so just to sort of summarize up, what the point about this case for everyone listening is, here's a settlor that ends up being the first protector. The court's looking at the circumstances and saying, well, you could exercise those powers in your own interest. And if you did that, you could find a way to effectively repatriate those assets back to yourself. And in doing that, they then come to the conclusion that if you're able to do that, then you don't have a valid trust. And this is an irrevocable trust that they're doing this to. The fact pattern is unfortunate because the settlor is not coming with a sort of clean hands and is not a good folk, but that's what effectively they're saying. So I think that, we'll do the lessons learned bit later on, but it's important to note this. It's a protector office that this is primarily being dealt with through. The fact that these remains a beneficiary leads the court to extrapolate that actually they can find a way to get assets back. And that just that risk alone gets you into a position where the trust then effectively is seen as illusory or invalid. Okay. Now, the last one that we'll do, because of time constraints, is Webb and Webb. And this is the latest sort of edition, as it were. So this is a matrimonial dispute. So this is not a creditor issue. This is a matrimonial dispute. Settlor created a number of Cook Island trusts. Settlor appointed himself as sole trustee. Already that's going to be off to a bad start, but not very usual, but that's the fact pattern. Settlor appointed himself as the consultant to the trust, which for our purposes is like a protector. Settlor is also a beneficiary of the trusts. Quite wide powers retained, so power to amend and vary, consultant consent, effectively the settlor's consent. Power to add and remove beneficiaries, the settlor could direct that, so not in the capacity as consultant. Power to appoint and remove trustees, consultant can direct that. Power to apply income and capital, trustee, well, that's the settlor himself. Trustee, no conflict rule is excluded to the extent that they can do things that are not in the interest of the beneficiaries. So court decision, cumulative effect of retained powers and roles, no effective alienation of beneficial interest. Sorry. And no extensive fiduciary versus non-fiduciary analysis. So when just David, looking at this latest edition, they sort of roll up all of what the settlor could do. They take into consideration the different roles and say that, in effect, it seems to be that the settlor is in too many different roles, has too many powers, and effectively, it's a tantamount to having a power to revoke or a general power of appointment. Is that how you read it? They just said, look, the cumulative effect of all of this is that you haven't done anything to alienate the assets into a trust.
Exactly that. I mean, they said he was wearing too many hats, or all hats, shall we say, and that they then drew this conclusion. It is somewhat troubling. I mean, the first issue is why didn't they just simply, if they concluded that he had a beneficial power which was valuable to him, which I think they did, because this is the clause 10 of the trust, whereby he could replace, it's an odd power, it's not add beneficiaries, it could replace beneficiaries. Yeah. So they concluded that ultimately he could end up as, quote unquote, the sole beneficiary. Yeah. And in this case, which is different to the Clayton decision, there was also that would have affected the backstop gift at the end of the day, so that he would have been technically the sole beneficiary. The difficulty there is why didn't that power sit on his balance sheet in the same way as it did with TMSF? Yeah. Why was that power, if it was beneficial, a matrimonial asset? This is the question mark, was if the assets are held in trust, they couldn't be part of the matrimonial division. Yeah. If it was held for his sole benefit, just a nomineeship, it was a matrimonial asset. Yeah. So it should have been just simply that his powers, insofar as they were beneficial to him, should have been on his balance sheet, and then we wouldn't be having this conversation. They didn't take that route, and what they decided was that his powers, that collection of powers and provisions, he was to be regarded as having rights indistinguishable from ownership. And they said that exactly as you put, because he was in a position to secure the benefit of the assets without to himself, without regard to anybody else. Yeah, yeah. The existence again of a power. Yeah, yeah, and particularly to reduce the beneficiaries to himself solely. Exactly, and just on the fiduciary non-fiduciary analysis, there is a perfectly orthodox provision in the trust which takes on a different connotation in this circumstance. And that is the standard provision that we have, whereby we remove the absolute prohibition on conflicted transactions.
Yeah.
All that does is stop the transaction being automatically void. You've still got to exercise your powers properly. You've still got your fiduciary obligations. But the court took that standard provision and combined that with the fact that this chap was the trustee.
Yeah. I mean,
so there was one other beneficiary, which was his son.
Yeah.
Nobody else in prospect. And to whom was there any true duty or obligation owed?
Yeah.
It was a very thin trust on top of everything else.
Yeah.
Which is another perhaps a sort of red light for us.
Yeah. Because if we go to the end analysis of this, it looks like if we were trying to do a summary, everything in the green looks as though it's okay. So if you've got administrative powers being reserved, they seem to be fairly standard. It doesn't affect the ownership of the underlying trust fund. So that would seem to be quite mild and not give rise to any of these risks. It's when we start moving the dial over to quasi-dispositive and fully dispositive powers, then we start to get into this new territory of illusory trust, particularly, and this is, I'm looking at power to revoke in particular, because there are a number of trusts in Asia that are going to be foreign grantor trusts, for instance, where power to revoke is quite important because it helps with the tax benefits that these trusts achieve. Now, if it's the case that we have settlors that taking on the ability to effectively call the assets from the trust, or even at a milder level, reorganize the trust so that in such a way that they can, a trust that's ostensibly irrevocable can actually end up being revocable by virtue of the way in which they can exercise powers in combination with the trustee. If that's the case, if that's what these developing lines of authority are, then it puts, we need to consider very carefully whether or not the trusts that contain settlor powers that are in red on this quasi-dispositive and dispositive, the more you put on the trust, the worse it gets in terms of this line of analysis. Because the more risky it becomes that if someone were going to have a pop at this trust, if it's going to be a divorcing spouse, or if it's going to be a forced heir or someone, then they would be arguing that that combination of powers, which I think everybody on this will think is pretty mild and pretty standard, given this line of authority, then becomes quite explosive potentially. So, I mean, what is that the right way of looking at this, David? The more that we move over to the right-hand side of this, this diagram, the more that we start looking at dispositive powers, the more we need to be concerned going forward.
I think that must be the case because of these decisions that we're looking at. That's the direction of travel. But, and this will be the issue, is to try to draft the trust in such a way that we can still go back to what we might call the traditional dichotomy. And that was a distinction between a state of affairs whereby the assets were immediately held to the order of the settlor, and you've retained your beneficial interest in those circumstances. Yeah. It's just a nomineeship. And those circumstances where the assets are held genuinely for beneficiaries who can include the settlor, but must obviously be persons other than the settlor as well.
Yeah.
Which are themselves subject to, let's say, a power of revocation. In those circumstances, they're not held immediately to the order of that power holder, unless and until he exercises his power.
Yeah, but
how do we get into that? You need to get into that second situation.
Yeah, but
the first situation.
But the problem is that these judgments are all. They're looking at the cumulative effect of this. So there becomes a little bit of an art to try and do this. We can't be quite forensic about this. So if we're a wealth planner at a bank, or if we're a trust company MD or business development person, then how do we get to a point where we know the limits? So where does the mix become toxic. That's going to be the issue going forward.
Yes, but you also want to be looking at it in a broad sense. You've got, let's say, what is sometimes in the American context called the revocable living trust.
Yeah, yeah.
Wonderful expressions that we hear. Everybody will tell you, the US experts, that during the life of the settlor, you can't sue the trustee.
Yeah.
And this is either by virtue of express terms or the way the law is developed.
Yeah, yeah.
In those, which of course, to innocent minds such as mine, that is a shocking statement, and quite clearly tells me that the assets are held to the order of the settlor, and they're on his balance sheet, they're in his estate.
Yeah, yeah, yeah.
How they become trust assets after his death is beyond me, and no one has ever explained it to me.
Yeah.
But the creation of that structure outside of a US environment,
yeah,
must be very dangerous.
Yeah, yeah, and I think that's.
I don't think that will come as news to anybody.
Yeah.
But what are we going to do with a purely orthodox revocable structure?
You're right, right.
I think we're going to have to try a little bit harder than perhaps in the past. You'll want a proper trustee. Now that doesn't, we'll talk about PTCs later on.
Yeah.
Whoever your trustee is must be and be seen to be acting properly.
Yeah, yeah.
And you don't want anything ridiculous in the trust, which at all suggests that there is no duty owed to any beneficiary. So these restrictions on disclosure of information, restrictions on being able to sue the trustee, breathtaking provisions that you saw in the AQ revocable trust in Bermuda.
Yeah.
It says you couldn't sue the trustee, you couldn't complain about anything done during the life of the settlor, this kind of thing.
Yeah.
They're obviously sort of red flags.
Yeah, yeah.
And then the more difficult thing of reducing the involvement of the settlor.
Yeah, yeah, yeah. Okay, I think the other aspect that I was looking at was position of protectors. Could we find a situation where, I don't think there's been a case on this yet, but we load up a protector with enough of these powers that in effect the trust is held to the order of the protector? Is it possible that we can have a situation like that occur? So for instance, settlor, I'll give you a simple example. Settlor confers a power of appointment on his son, and that's a general power, so that effectively the son can do what he wants with the trust fund by way of the exercise of that power. Do we, under this current thread, do we then say that, well, in effect, this is a nomineeship for the son going forward? I mean, the ramifications on this, in other words, do we need to analyze it? I know we need to be careful if it's the settlor. I know that because he's the one that's effectively alienating the property in the first place. So we have to make sure it's a perfected gift in that way. But then once it's into the trust, if we've got so much powers and provisions in the trust to a non-settlor, could that effectively make the, subject the integrity of that trust to some level of doubt? Using the analogy of what we've just been discussing with the settlor, is that?
Well, it's always been a risk, but it was one where we distinguish between assets held to my order and the holding of a power not yet exercised. That dichotomy. Right. Now, plainly, the spouse, taxing authority, or creditors of the son will have something to say.
Yeah. Faced
with this situation, and it would be naive to think it's not a possibility. It is definitely a possibility.
Yeah, right. Okay, right. So let's move on because we've got time. Okay, so bringing it back to regional, Hong Kong and Singapore, and thinking about how is this developing line of cases going to impact the position that we've got in both jurisdictions with respect to their trust laws as they currently stand. So if you look at the Hong Kong trust law, of course, by basic law, you apply English common law to Hong Kong. And you have, within the updated Hong Kong trustee ordinance, settlor reserve powers under section 41(10), or X rather. And this is the provision, reserve powers to settlor. There's two subsections. The first subsection deals with the settlor effectively reserving to the settlor any powers of investment and asset management function under the trust. Now, just before we get to the second one of the questions that I would ask on this is whether or not, and it's a topical one because it comes up quite often, is whether or not the fact that we've had in Hong Kong express legislation that says you can reserve effectively a power of investment or asset management, is that to the exclusion of all other powers, or effectively is it non-exclusive? So I did some research on this and I looked at the consultation paper leading to the amendments, and there's a section in that where they actually talk about the fact that case law will continue to apply and the reserved position of powers generally at common law will continue to apply generally, but they'll just carve out the provision dealing with investment powers. And I think in that there was some feedback that it should be more extensive. That was rejected. This was the only thing that got through on the amendments. So I think Hong Kong answered that effectively these provisions are declaratory of a position that was already there at common law anyway, and they don't authorize something that we couldn't have done anyway at common law. They just make it beyond doubt that in itself will invalidate the trust. That's if I was just asking a question, David, on this, that as a matter of English common law, was it ever the case that a settlor could reserve no powers at English common law, and that you needed statutory intervention to award powers to the settlor? Was it ever the case that we had that position?
No, we can go back quite a ways to settlors having direction-making powers and consent-making powers over investments, right, asset management, and such like.
Right. So
it's perfectly orthodox.
Right.
Do that.
Now, the second part of this, the subsection 2, it's an interesting one, because if we run the scenario, and this is the question to you, if I run this scenario, the settlor holds investment powers personally, so he can exercise them in a non-fiduciary capacity. And then we have this provision that the trustee who acts in accordance with the exercise of those powers or functions is not in breach of trust. Then do we end up in a statutory position that no one's responsible for this trust? So in other words, is it a core obligation breach, or could we see a Hong Kong court looking at these statutory provisions, if it ever comes up, and saying, you can't have a trust without anyone having an obligation? Or what would be the issue that could come up in this?
This provision raises so many questions. I mean, it's extraordinary at one level, but reliance on it without caution, I think, would be taking a risk.
Yeah,
it's going to be read, no doubt, but by the Hong Kong court is extremely sophisticated. Yeah. As are the council before it, and it will be read just as you've been doing in the context of the legislation properly. It may well be the court is saying, well, a person that is acting improperly, misusing its powers, is not exercising.
Right. Yeah.
It isn't a proper exercise, and that's not covered by this.
Yeah. I suppose.
I think a trustee that is actually aware of something improper,
yeah,
ought to be very cautious and should be, in an appropriate case, would want to take directions from the court. But
yeah, but certainly from trustees' perspective, relying on a settlor, because this is the other thing that will come up, because it's an investment asset management function. The question that comes up is, should the trustee be looking over their shoulder each time that they get a direction? So should they be saying to themselves, is this a proper exercise of this? From the settlor's perspective, he'll be saying, there's no such concept as a proper exercise. I can do what I want. So do you see what I mean, David? In terms of the practical manifestation of this on the ground, what should we be doing? Just saying, well, I've got a direction, I just follow it. That's it. He's the boss. Or, yeah, because that's...
Well, if only that were the case. Right. As you know well, in the United States, they've had this phenomena of the directed trust. I mean, it's it's now, it started off as a notion, I think, in Delaware in the 80s or 90s. And it lay rather hidden for quite some time until there were one or two decisions. And it's taken America by storm. All kinds of factors can be taken into account, but the fact it's now completely mainstream, so that you've got a Uniform Directed Trust Act.
Yeah.
Just become more conservative and mainstream than that. So it's not wacky legislation at all. And in these circumstances, it's not an absolute protection. There's still a job for the trustee to do, because legislation itself has got certain limits to it. There is a provision in the Bahamian statute which was intended to reflect that process of settlor of directed trusts, and that contains a limitation in relation to any actual knowledge of a dishonest exercise.
Right.
Dishonest is to be interpreted in that broad sense.
Yeah.
That's the old section 81A of the legislation. I know about it because I was involved in its drafting.
Right.
You've got these things, but there's nothing like that expressly in the Hong Kong situation.
No. So what do we say to, there's going to be trustees watching this, and they'll be in Hong Kong, or they'll have an affiliate in Hong Kong, and they potentially could be, trying to rely on the practical aspects of this provision. We would say that it's not a blanket exoneration, effectively.
On the basis of what we're looking at on the screen today, you would have to suggest some caution, wouldn't you? I'm sure there's been no end of advice given on this by Hong Kong Counsel, and one would expect it would be somewhat cautious.
Yeah. Okay. Now, coming to Singapore, same issue, application of English common law through application of English common law Act or English Law Act. Trustee Act, and this is the provision under Singapore, the equivalent to Hong Kong, as it were, Settlor Reserve Power, section 95. This is the actual section here. There's no trustee exoneration provision included, but it's pretty much the same as was you would have seen in the Hong Kong analysis. The same question arises whether or not this is exclusive or non-exclusive. And I asked that again because I actually took it upon myself to do a poll on this, and it was over 8,000 people viewed the poll, and it came back over 50% said that you couldn't reserve more than the power of investment to a settlor under Singapore trust law, and they're relying on clearly section 95 for that. But then that brings the whole issue back of at English common law, but for a statutory provision, you couldn't reserve anything to a settlor. Is that right or wrong? And we've already said that no, as English common law, you could reserve more than just the power of investment as a matter of law. So I think that in terms of the exclusive, non-exclusive extent of this power, I went back and looked at the Hansard and the actual introduction of the 2004 amendments and read the Deputy Prime Minister's comments at that point. And it was almost the same as in Hong Kong, in the context of, we're not going to effectively seek to codify powers. We'll leave it as a matter of common law, but in the meantime, we'll at least codify powers of investment and management function. But we won't say anything about the common law position as it now stands. In effect, that's what the Deputy Prime Minister was saying at the time, and then the head of Ministry of Law as well. So I just asked that question again. As a matter of English common law, is it appropriate, is it valid for a settlor to reserve powers more than the power of investment, or would it be invalid?
Clearly not. Don't misunderestimate the scope of this, because it's pretty wide. I mean, it's powers of investment or asset management functions, which covers a very broad range of activities. So you may have to be a little bit more specific, not today necessarily, but to say, well, what else are we talking about? What other roles or functions are we referring to?
Yeah.
What, if you get into asset management functions, I mean, that's it isn't just buy and sell. It's how to vote the stock of a company, whether you join in a corporate transaction or not, and so on and so forth. Whether you engage in trading and so it's pretty wide. What are we left with after that? Well, hiring and firing trustees, revocation powers, and so it's not quite as narrow as at first sight it might.
But in looking at the section, you'd say, well, does that mean it can only exclusively be the settlor that can reserve these powers? Or can you not, in other words, you can't even have a protector committee that does this because it's only exclusive? Because I don't read the section in that narrow way.
Well, isn't it directed at a particular concern? And that is the reservation of powers by the person who creates the trust. Result in no trust. The concern was it could have resulted in no trust having been created at all. That, of course, can't happen if you give the power to somebody else.
Right. So that gets back to the whole: is it non-exclusive or exclusive? So I think that it may have been mechanically interpreted as meaning only the settlor can reserve this. No one else can do that, and you can't have a subsequent power holder because it's clearly saying only the settlor can do this. And I don't think that certainly from reading the Hansard, I don't think the minister was definitely not saying that. It's not that as a matter of law. It might just be a misconstruction on certain segments of the community that seem to take it literally, that it's almost displacing English common law to that extent, which I don't think was the intention at all.
Yeah, as I say, I don't know that it has so often been said that the not the reservation, the granting of a power to a third party necessarily called the trust into question.
Right.
Almost all of this is related to what has the settlor done?
Yeah, exactly. Yeah.
It's the same issue as in Webb and Pugachev. Has he disposed the beneficial interest?
Yeah, exactly. They don't have the exoneration clause in the Singapore version. So I suppose you, as a trustee, you need to figure this out. Do I supervise or don't I supervise, or what's the limits of my potential residual liability if the settlor is, I don't know, wrongly investing or otherwise, maliciously investing. I don't know if you can do that, but so there's nothing said about the trustee's position in all of this. So then where does that then leave us?
I would imagine this doesn't change anything in relation to the trustee's duties. It only speaks to validity and invalidity. Right.
Yeah. Okay. Yeah. So their obligations are the same.
Whatever they were previously, they probably still are today.
Right.
And we all have looked at this. I'm sure many of those listening will have looked at it, and colleagues from Singapore and Hong Kong will have looked at it, and we know that very much it's the reservation of powers and the problem of knowledge.
Yeah.
So
okay.
It's a complicated situations.
Yeah. Okay, so just going on to summary of this, position Hong Kong, Singapore, investment powers, fine, that's no problem at all. These are the range of powers that we can encounter. It's not exhaustive. The issue that comes up is Singapore, Hong Kong will have, because of the, applying traditional English common law principles, the ones in red will be an issue going forward, as it already is. I put the others in yellow only because it deals with the context in which and what the extent to which they're trying to do that. But certainly from the developing case law, from a Hong Kong proper law, Singapore proper law trust perspective, they will have, as it is in the UK or any other Commonwealth jurisdiction that doesn't have a statutory code, these are going to be some of the issues that are live now in the red. How much do you reserve to the settlor and in what way? these can have implications to whether or not the trust could be found to be invalid. Is that fair?
I think it must be. It must be. I mean, we have these decisions. They're fairly forthright, and we're going to have to manage around them.
Yeah. Okay. Now, the last bit, countermeasures. Now, just we'll canter through this because we're getting low on time. In terms of three things will come up. What can we do better in terms of drafting, given that we've got these cases? If we're going to continue to do Hong Kong, Singapore trusts, what sort of best practice could we start to incorporate into trust drafting if we modernize? Should we start to decant and just use private trust companies, or are there risks associated with that? And what should we do about using, let's say, more modernized offshore trust jurisdictions, some of the more traditional offshore centers, instead of, or in addition to? So looking at the drafting amendments, I'll put them all on the screen so that we can run through in whatever order. But reserve powers to avoid. Should we be saying things like this power is not fiduciary, this power is held in a fiduciary capacity, making it clear? Excessive restrictions that we should be aware of that could have a negative impact. For instance, limiting the rights of access to information. What can we do in terms of particular best practice drafting, given that we've got these lines of cases coming through? And undoubtedly, everyone's going to be arguing this on litigation cases going forward, that you've got an illusory invalid trust if you've got any reserve position on there. It's going to be the standard pleading, I suspect. Is there anything we can say about this, particularly on the drafting side, David?
You can go in reverse order there, can't you?
Yeah.
The inclusion of this of these restrictions has got to be looked at very, very carefully. There is a difference. You know, a complete restriction on beneficiary rights to information will often be overridden. It won't work.
Yeah.
Rather than the trust be set aside.
Right.
And that's been done on a number of occasions. So something less, you know, might well be acceptable, whereby you say, well, persons under a certain age don't get information.
Yeah.
You'll know precisely why. We're trying to protect them from themselves. So it's possible that the hope is that you don't do a complete blanket across the board. Some, you know, you've got one class of beneficiaries that do have information, others that don't. So you satisfy the requirement for there to be a genuine tension between the trustee and the beneficiaries. The trustee has got to owe some duties. Yeah. Those duties are going to be enforceable.
Yeah.
Absent information, they're not.
Yeah.
So that's a no-no. If we're going to say, and it may well now be necessary to be more explicit. But if you do say fiduciary, and you've got to explain what you mean by it.
Right. Yes.
It's not enough just to say that, because if we say it's fiduciary, we're going to say, does it impose positive obligations or just negative obligations and so on?
Yeah. So you've got to do a proper job on, and you can't just say that the office is fiduciary. You need to pick out the powers and then expressly discuss each of those powers' qualities.
Indeed, and what is it that's expected?
Right.
Of the holder of the power. I mean, there is a debate, for example, that if you are a protector with the power to hire and fire, how big an obligation is that? Are you responsible if you fail to exercise it? Yeah. In circumstances when you ought to have done.
Right. So that's quite a lot more trust drafting than most of the trust deeds, I suspect, have nothing on this. And so moving to a more modernized approach is going to require quite a lot of work to embellish exactly what you're suggesting that the holder has.
Potentially more than that, because when you get into the fiduciary nature and what it means, you will test the patience of your clients.
Yes.
They'll just throw their hands up in horror at the complexity of it all. Yeah. So it's not an absolute requirement that you've got to start indicating fiduciary or not, but in particular circumstances, it may well be appropriate.
Right.
And some jurisdictions did it automatically for many years, didn't they?
Yeah. Yeah. Yeah.
Albeit without explanation.
Yeah. What about powers to avoid? Because we're undoubtedly, people listening to this are going to say, is a power to revoke still good or not? Can we do it or not? What's the position on powers to revoke? Because I've got, tens of hundreds of US connected clients, and we've got all these trust deeds circulating. My precedent has this isn't included. What should I do about this going forward?
Well, I think we're back to that dichotomy which I explained a little bit earlier. The notion, are the assets immediately held to the order of the settlor, or are they in fact held for the benefit of beneficiaries other than the settlor, be it in addition to or not?
Yeah.
With that state of affairs continuing until the power is exercised, and you just got to get into that second situation.
Yeah. So, yeah,
my guess would be that if the only factor is that there is a power of revocation, but everything else points to a proper trust, then it would be an earthquake, and upending a couple of 100 years of jurisprudence to say that you can't have a power of revocation.
Yeah. Okay, a couple more and then we'll wrap up. So private trust companies, the issue here is obviously the settlor is not having reserved powers, but the settlor sits as a director on the private trust company. This is very popular. A lot of these private trust companies are limited by guarantee, and the settlor sitting. I don't know to the extent to which the settlor sitting there on their own. It's quite possible they are on their own as the sole director. But the question comes up again: is what's the illusory trust risks with this? What's the risks of director liability? What's the risks of sham? And then what should we be doing in terms of the best practice for settlors that decide that they want to sit on the BTC boards? So I know there's quite an array of issues there. We can pick out a couple because we're running low on time anyway.
I think we can deal with this fairly generally. The principles that we've already touched upon.
Yeah.
Apply in every way to a trust whose trustee is a PTC as it does in this circumstance. Plainly, we do not want. It is dangerous to have the settlor as the trustee, and it rather surprises me just how many times that's cropped up recently. But I imagine in the world that you are operating, that's very, very rare. But the reason you wouldn't want that is the reason why, if you're going to have a PTC, it's got to be run properly.
Yeah.
And effectively, perhaps one unscientific test is to look at the situation for these purposes by saying, well, if my directors were the trustee directly, what would be the situation?
Yeah. So if the settlor is there as the director, then you're back into the same problems.
Yes. I mean, you probably won't save much, if anything, if you do the things you can't do directly to do through the medium of a company.
Right. Yeah. Okay. I think that's a good way of looking at it. I just mentioned on the director liability, there will obviously be situations where on PTCs, we don't have just the settlor sitting there with all the risks that has. But what's the position on directors being held liable for breaches? Because, when you look at a PTC, it's almost judgment proof, ostensibly when you look at it just from the round. But is it possible that we'd have movement there, directors could be held directly liable for losses to the trust fund that they've effectively procured?
They're not judgment proof, even at the most extreme end. It's just complicated to get through the barriers. I mean, you would sue. Today, you can sue the trustee, get your order, get your claim. That's non-scientifically call it your damages claim, your rights of recovery, your accounting entitlement, and then the you have to put the company into liquidation, and the company has to, the liquidator will pursue the directors.
Right.
They're not safe.
Right.
In that sense. And if it's a big enough claim, you can expect it to happen one day.
Right. So you'd use it through the insolvency route.
You can. It's just very complicated and time consuming. So everybody wants to try to see, well, can I claim directly? And as it's been made clear in a number of jurisdictions, directors don't owe duties to beneficiaries.
Right.
They owe duties to the PTC, to their company. And the question is whether, in very special circumstances, the situation could be different. And that is where it's a single purpose PTC.
Yeah.
Only function of the PTC is acting as the trustee of a particular trust.
Yeah.
It is suggested in those circumstances that the mischief that is behind the rules that the director only owes duty to his company,
yeah,
may not have the same amount of traction.
Right. Right.
As in a case where you're going to have multiple obligations, multiple potential creditors, and so on. Yeah.
Right.
There's no decision to that effect. It was, the position has been reserved in I think 2 cases.
Right. Right. But it's only a matter of time, I think, given how the proliferation of use of PTCs.
There's no question that the use of a PTC raises issues. That's one of the issues. There are a whole bunch of others. I and numerous others have been in court over PTC problems.
Yeah.
And you move from having trust problems to having corporate problems.
Yeah. Right. Right. Okay. Okay. Right. Last one. This is again remediation. Should we be using the offshore jurisdictions? They all tend to have comprehensive reserve power codes in their trustee acts. The question that comes up is a lot of them will have total reservation provisions where you can reserve the whole list of powers without the trust being held to be invalid or in any way affecting its validity. And then there are some that contain the trustee exoneration provisions that we were discussing in terms of Hong Kong. Question that I'm asking on this is a rather narrow one. It's choice of law and recognition from a Hong Kong perspective. So if we were to habitually create foreign trusts with respect to a Hong Kong client or foreign trust with respect to a Singapore client, then one of the risks that would, or one of the arguments that might be raised is that the courts may not recognize that particular foreign trust if there are so many reserve powers, or types of reserve powers would be such that if you try to do it in a traditional jurisdiction, it would be well on the line of being potentially illusory or invalid. So in our list, the red side of the list of quasi dispositive and fully dispositive powers, what's your feeling about the risks of that in terms of a Hong Kong court or a Singapore court? Because Hong Kong applies the Hague Convention, so it has some backing to recognize foreign trusts. Singapore doesn't have that. But what would be the weight that the court would have to put on a claim that we can't recognize a Jersey trust because it has too many reserve powers, and that would be, in a more traditional context of Singapore, that would be likely to be held to be invalid. So therefore, we shouldn't validate that trust when it comes to a domestic scenario. Well,
any court is going to hesitate to recognize a voluntary choice if it perceives that choice has been made for the purpose of avoiding some aspect of local law, which is considered to be of fundamental importance.
Yeah.
Now, it's impossible to say what that might include. Where is the mischief in all of this? Is the court going to say that an inter vivos lifetime choice by a settlor, which might otherwise have exposed the structure to some form of testamentary disposition analysis.
Yeah.
Is a court going to say, well, this distinction of testamentary and non-testamentary is so fundamental to us that we can't allow it to be avoided, qualified in some way?
Yeah.
If indeed there's a prior decision as to whether there's been any avoidance at all, because most people would say that the various laws that you're referring to are merely declaratory of the existing position.
Yeah.
Assuming a court were to conclude that's not the case, that they go beyond, then it becomes a question of what's the policy issue behind those any provision which is altered, if you like.
So I suppose we can't.
I don't want to use the word avoidance because that carries a connotation, but the moment.
Yeah. So I suppose there is that potential, particularly if it's got solely Hong Kong connecting factors or solely Singapore connecting factors. I mean, that generally is not going to be the case. Many of the trusts will have settlors from other jurisdictions. They'll have companies from different jurisdictions. They'll have beneficiaries in different. So there'll be a whole array of different connecting factors, which won't just be fully domestic. But in a fully domestic scenario, that must be a risk.
Yes, it's certainly a factor that someone's going to have to give careful thought to. But it's if you take the great big, there's this pretty substantial step of wanting to choose a foreign law in circumstances when you would otherwise have chosen Singapore, Hong Kong, or whatever. That's the big issue. If you're going to go away from the locality, then it would behove you to do that properly. Yeah. And therefore you would, if you're going to have a PTC, well, you would have a PTC in one of these other jurisdictions. And maybe your underlying assets would comprise a holding company incorporated in that same jurisdiction.
Right. Yeah. Okay. Yeah.
You're building up your connections with that jurisdiction.
Yeah. Yeah.
All of that is a big step. The first big step is the choice to go overseas.
Yeah.
In the first place.
Yeah. Yeah.
So you these days, people are going to United States, and people are forming PTCs in different states and what have you, and such. So I'm not suggesting everybody should be doing that. It's just it's on the smorgasbord, but it's not impossible.
Okay. All right. Okay. I think we'll just go on to next actions, and I'll just canter through this. This is basically just the advice at the end. We need to have a look at and review your trust design protocols. I mean, look at out-of-date trust precedents. Look at precedents that have loaded up dispositive powers. And then in terms of the way in which you offer that to clients, it's quite important in light of these cases to really review up not only the precedents that you have, but the way in which they're being marketed to clients going forward, particularly if you're allowing extensive reservation of dispositive powers so the client can claim back the assets, is also a beneficiary, etc. Risk review the legacy business that you've got on your books, and that's quite an important one, particularly where you've got existing structures that are aggressively structured when it comes to reserve powers. It's quite an important consideration to perhaps look at a way in which you can engage clients on maybe remediating some of this, or looking at the risk that they could potentially be facing and seeing whether or not there's a way of trying to mediate that. If they have active risks where they're in their personal lives, for instance, that could involve the trust, then that would be something to look at. So it's not just looking at new business potentially, it's also looking at the legacy business, which is always going to be bigger. New business protocols, be very careful about what you can promise without any sort of admonition around whether or not the reservation of certain powers would not give rise to potential risks. Need to perhaps start talking in that way with clients and have a way of expressing the risk framework to them going forward, not just presenting them with documents that they can just sign. And then finally, on going down to keep an eye on this case law, keep an eye on the developments in this area. It's still going, it's still developing, and we'll have to see whether or not there's a sort of high-level case that comes through that starts to rationalize some of these worries that we've got. And then it all comes down to educating staff and executing any remedial actions. So that's the main message, is trying to educate staff and understand the risks involved and then do something about it going forward. Okay, on Q&A. So I think we've only got a couple here. I'll see whether or not how much we can do. Some of this may actually need to go offline. So I'd invite any of the attendees that are writing this, but we can try and at least answer some of this. If the power of investment is given to the power holder, does this mean the dispositive power will bring the trust to expose to tax in jurisdiction like Singapore, as it's seen? No, I don't think I will pull that one. Assume that the trustee explicitly states that a protector is a fiduciary. An individual who is both a beneficiary and protector would put that individual as a protector in a conflicted position. Would appointment of a beneficiary to a protector be then an effective appointment given the apparent conflict? So you're saying in this one, David, we might well answer. You've got a beneficiary, and that beneficiary is also a protector, but we've also expressed that the protector is in a fiduciary. Let's say that the powers are nicely expressed as being held in a fiduciary context, and they're well drafted. What's the position of the potential conflict there, that this individual would probably want to act in their own self-interest, but they're actually holding an office where they can't? So
yeah, well, their position is exactly the same as any other fiduciary, and if indeed they're in a position of conflict, then they can't act, and it's for that reason that a well-drafted instrument will neutralize the conflict absolute prohibition. It doesn't get you off the hook, as we said earlier. You've still got to do the job properly, but this has cropped up in numerous scenarios. The most recent one is in the pension fund world, whereby you've got to have pensioner trustees. They've got to have a role, and they're going to make decisions in where there may well be conflicts. So that is a real problem, and it's got to be dealt with expressly. Right.
I think you've got a variant of this. If the settlor is acting obviously recklessly, this must be in the context of a reserve investment power, gave an investment direction to the trustee, and the trustee acts on it, obviously in proper direction. Would the position change also? Would the position change if the settlor is made a fiduciary in this aspect? Would the liability become the settlor's? So I think this is a whole discussion point around the mix of obligations on these reserve powers when it comes to the investment side. And we've got the trustee being aware of what we would consider to be a wrongful direction, or one that's obviously designed to somehow put the trust fund in danger. So recklessly. So I suppose the obvious one would be, let's sell all of the investments and invest all of it in Bitcoin.
Yeah.
So if there's a direction like that, let's say, which you would say in some circles, they would say, well, that's an extraordinary use of that power. What should we do?
There are so many points. First of all, the dichotomy fiduciary, non-fiduciary in relation to investment powers. To suggest it can be non-fiduciary requires quite a lot of thought. What does that mean?
Yeah.
This is frustrating for many people listening, but you do have to be careful about this. Does that mean that I can sell my power? Does it mean that I can promise to exercise it if I get a kickback from the investment manager that I've chosen? If I can exercise it in my own interests, I'm not a fiduciary. I have no duty of loyalty in an absolute sense. Does it mean I can tell you to buy assets at an overprice, and so on and so forth? I mean, nobody, generally speaking, thinks about these things, but that's the state of affairs where you could find yourself. And of course, because of that, most courts would say that you would need something pretty explicit before you go to that situation. So then comes the other. It's the other side of the coin. To if you say something's fiduciary, you better explain what you mean. If you say it's non-fiduciary, you better explain what you mean as well. So that's it. Imagine that it is fiduciary in the sense that there are you hold the power for the benefit of others,
Mm.
and you've got to take that into account. So you owe duties.
Mm.
There are duties owed by both parties in that circumstance, in absence and special provision.
But could you ever
you definitely, the third party, the power holder, will definitely be sued at some point.
Yeah, because I was thinking about, do you think the court would ever accept that no one has any obligations?
Well, the problem with that is how far does it go? Because it goes far enough, you have no trust.
Right.
So you can narrow the obligation in some way, but there's no doubt that if you're going to fight a power holder that owes duties, that person is technically, if not actually, in the firing line.
Yeah.
Generally speaking, people tend not to sue the settlor. It's usually not a healthy move to take.
Yeah,
but it's got to be recognised that that person owes duties not complied with. They will be, because these things are a responsibility shift. It's a division of obligations. But insofar as the trustee is not completely absolved, which would be very rare, the trustee is still in the firing line. And it's a devil of a business to know exactly what the trustee, what matters to the trustee and what doesn't.
Yeah, and that comes back to the point you made about being very explicit about how you can explain those obligations. Because if you don't, then the court will fill in the blanks.
Exactly, but
right.
and it's because of that uncertainty that the statutory provisions for direct trust have come into play.
Right. Yeah. Okay.
Why you have these provisions in the United States. It's why a provision was introduced, the Bahamian provision, which I talked about before, and you in a slightly different way, you've got your Vista Trust in BVI.
Yes. Right.
Regulated division of responsibility, so
right.
people know where they stand.
Okay. Right, David. Thanks very much. I think that's probably enough for today for everybody listening in. We're at an hour and almost an hour and a half. What I just say is I'm forever grateful for you to spend the time with us talking through these issues. It's very important. It's incredibly important for Singapore, Hong Kong, because we have limited statutory codes on this. And there's going to, there needs to be some realization that these sorts of reserve powers can be quite dangerous for clients. So I think it's a very timely talk, and it's very important for people listening. And I thank everyone who joined us, who tuned in. As I say, the slides and as well as the recording and the podcast will be made available afterwards. And I'd just like to thank David once again for spending time with us on this one. Thank you very much, David. And I think we'll just leave it there. Thanks, everyone.
Thank you very much, too.
Thank you.